First of all, distinguished ladies and gentlemen, Assalamu alaikum. Yesterday, I took the data of the entire country, but AJK was missed out, and so was Gilgit-Baltistan, and that's my apologies to judges from both these areas. I did not have access to data, and the Law and Justice Commission of Pakistan at that time also did not supply me with data for AJK and for Gilgit-Baltistan, so my apologies. I'm going to make sure that next time there is a session we include that data in it. So the judges from both these areas, once again, my apologies for that. Yesterday, in the domain of inclusivity, we talked about representation as one key area, as an intervention. And we also talked about jurisprudence, which was very progressive, leading towards inclusive judiciary or inclusiveness, or promoting inclusiveness. Today we'll talk about a totally different thing, that's the structural interventions. And that's what I want to talk about. I think, first of all, at the very outset, let me say that it is a pretty complicated area. Do not take everything that I say to be, a truth in that sense, because we don't have a study on the subject, first of all. So my information is my experience that speaks through this session that I'm going to share some of these ideas. It also depends on some of the conversations I've had with some judges. So I don't have any solid empirical data to talk about the structural barriers being faced by the judiciary and the district judiciary in particular, and what structural interventions are required. So whatever I share with you would be some of my ideas which I've gathered through my experience earlier as a Chief Justice of the Lahore High Court, and my interest in the subject and my conversations with a couple of judges here and there. The other thing of importance is that structural interventions would obviously be, once we identify what the structural barriers are, what are the problems, structural problems faced by the district judiciary largely, and otherwise judges at the high courts and the Supreme Court, and then we can intelligently talk about what interventions are then required for that. So, to my mind, I've just identified four big areas which I think we can divide the structural barriers into. And this is not exhaustive, as I said, it's just my own understanding of the subject. Somebody who's thought about it really. Ideas, I think. Judiciary Act. So how do we constitute the district judiciary? It could be through the Civil Courts Ordinance or the Criminal Procedure Code. But what about the terms and conditions of service? There is no law as such on it. The law is the rules, which are pretty scanty as far as Punjab are concerned, and they largely rely on the civil service material or rules of notifications. So it's largely adopted from the civil service, and that's how our district judiciary is largely structured. And that's perhaps also the reason we don't call the officers or judges of our district judiciary judges, but they've been referred to as judicial officers, which personally I don't like as a term. I think they are judges, and that's internationally the term, judges for district judiciary, and justices for constitutional court judges. That's how the global practice is. But somehow, because of our close nexus with the civil service laws, and we've just adopted some portions out of it, that the culture that's developed is of judicial officer. and largely reliance has been placed on whatever notifications or facilities been granted to the civil service sort of seeps into our system also. But we've not, in these last 75 years, other than some courts, I don't know, I think Balochistan might have come up with an act also, but largely Punjab and other provinces have not come up with a judicial service act as such, which could really talk about things exhaustively and maybe meet some of the structural barriers that I'm going to talk about. So one is let's talk about a little about the service structure itself, and whether at all that service structure, the way it is presently, is causing a barrier, and we require some interventions to deal with that. And I'll come to that. The second area is the judicial policies that will actualize that act or the service of the district judiciary. Largely, this discussion is about district judiciary, but we can certainly, take it and extend it to the High Court judges as well as the Supreme Court judges. So the judicial policies, and by that I mean policies issued by the High Court in regulating the affairs of the members of the district judiciary or judges of the district judiciary, is another thing that we need to consider, whether all those policies are gender sensitive or not. So the second area is the judicial policies and who makes these policies and all that, and I'll talk about that in a minute. The third is the actual hardcore brick and mortar infrastructure barriers, the working environment. We touched upon that yesterday in the shape of toilets and all that, but there's more to it. And we'll talk about the working environment and how does a woman judge feel in her environment as a judge in the district judiciary or even at the Supreme Court or at the High Court. And that I'll come to. That I think is another barrier. Then there's another barrier for which I still don't have any information or expertise to talk about, but it's certainly a barrier. And that's how does the legal education, the legal profession dealing with women, and whether at all it is inclusive, whether at all it is gender sensitive, and whether at all it is promoting women into and propelling them to come into the judiciary later on. How does the law firms work? How do the law schools work? This needs to be seen, and whether at all they're conducive, and are they really preparing young women to come into the profession. When I say profession, I mean the judicial service. And lastly, I would think there are serious cultural and social barriers also, which stand in the way of women to come into the judicial service. Now, once again, I'm no expert. I'm not a sociologist. I have no expertise, neither do I have any study to understand what are those patriarchal interventions or problems or barriers which are causing this. I hear that a lot of people think that if a woman is gone or their daughter is becoming a lawyer, it's a bit rebellious on her part to become a lawyer, and if she fights for her rights and all that, that makes people uncomfortable. So in a patriarchal society, anything can happen. I can't really put my finger on it, but this is I get a sense that culturally and socially there are issues which are also impediments in the way of women to come into the legal profession, leading into the judicial profession. So I look at it, I start off with the first one, but I look at the whole issue with a constitutional lens, because that helps me cut through this. So I start off, it was referred to yesterday also, Article 25(3) to start off with, because the Constitution allows us to discriminate in favor of women or take that affirmative action. So the main plank of most of the policies and the law that one wants to structure later on would be, because the Constitution allows us to go ahead and prefer women over men. And that is very important. That's a constitutional support that you get. And read with the principle of policy, which is Article 34, which says that steps shall be taken to ensure full participation of women in all affairs of national life. That the word full participation is there, and when you read it with Article 25, which I'll repeat for people who might not recall, is that all citizens are equal before law and are entitled to equal protection of law, but nothing in this article prevents the state from making any special provision for the protection of women. So we can go the extra mile for women, and we may, to ensure that there's full participation. Yesterday, we discovered that 16% of our women are in the judiciary. And we also discovered that the demographics of this country is that 50% of, almost 50% of the population of this country are women. So we saw there's a gap. Why isn't that demography reflected in our judiciary? Why do we are stuck on 16%? Why can't we move it up to, ideally, 50%? So that's the objective of the entire symposium, as I see it, that how do we move up that 16% to 50%, and what is standing in the way? I mean, what are we supposed to be doing, what are we not doing that we should be doing, that we move 16 to 50? And then we talked about representation, we talked about other things, but in that context, in that very context of moving that percentage from 16 to 50, we talk about structural interventions, and I've highlighted some of these areas. So with these two provisions of Article 25(3) and 34, I would sort of also refer to Article 14, which is right to dignity, which I think is a very strong fundamental right, and then right to liberty and life, that's Article 9. So this basket of constitutional rights need to be behind us to look at the policy and the legal profession, the legal area that we need to talk about, the Act and the law of the Service Act itself. So coming to the first one, legal barrier, that's the legal framework and the construct of the judicial service. So first of all, as I said, there is no judicial service.
Hello, hello.
These years we never came up with this.
Hello, hello.
So what would be the fundamental areas that one would like to consider when you sit down and come up with the Judicial Service Act? So first thing to my mind would be to concentrate on the appointment process. There has to be a full-fledged chapter on appointments in that law that we hopefully would make one day. So when we talk about that, what kind of appointments? And there I would say that we need to consider gender quotas. That's to my mind very important. I think that draws its strength from Article 25(3) itself. This is irrespective of the fact that yes, on a general seat a woman can certainly apply, but in addition to that, this is not belittling in any manner the women applicants who apply for this position. In addition to that general seat, there has to be that extra mile that Article 25(3) says. If you really want to push up the number from 16 to 50, there has to be some gender quota. And I just discovered this morning that we follow in the district judiciary the notifications of the government in our appointments in the year 2010 that I discovered in Punjab. There was a 15% quota that we followed for women at that time, and then I don't have much research on the subject whether it was followed later on or not, but there has been some sort of notification followed earlier by the High Court in Punjab in appointing some of the district judiciary members, and that was 15%. So I'm saying other than the general seats, there has to be the general quota looked at. And that's something I'm leaving all these thoughts for all of you to consider and percolate, and also for the panel that comes up to consider whether at all this is right or not. I mean, this is not a final word, but I'm just saying these are some of the ideas. Secondly, it could either be gender quotas or the women applicants could be considered first. And if they do not make it, then we move on to men, because we're giving preference to women. So this could be another option provided in the law, that if the applicants would apply, this law would stand as long as Article 25(3) stands, because 25(3) is allowing you to do this. So there could be that you give preference to women applicants first, and if they do not meet the criteria, then you move down to men and consider them. The recruitment committee, however, must have women. This is very important, and because it is to consider women as there will be applicants who are women, so the recruitment committee has to have women, and ideally if such a law promotion that is merit-based, and there is a very intelligent criteria developed, and we give merit the due credit and take people up the ladder so that they're not stuck, because everybody has to go up the ladder first. But people who are clapping must remember that there will be a merit-based system. So we'll see. And while doing that, we could also then go the extra mile, because you didn't hear this one. You go the extra mile and give preference in that promotion to women again, because of 25-3 again. So that, now I hear the other thing. So that could also be, and I'm just thinking, that could be an idea. So, as you see, I just read this quote of Melinda Gates, and I thought it was very interesting. I want to share that. A woman with a voice is, by definition, a strong woman. So I'm saying the minute you get more women into the system, the voice is going to become louder, and I think they'll take care of their matters themselves. Then comes the other issue, which is very critical. It has happened now, it's now a political issue to my mind, is the lateral entry of additional session judges, for additional session judges from the lawyers category. Now, to my mind, if you look at the system, the blockade is because of this also. People are not moving up the ladder from normal civil judges onto additional session judges because there are 40% are coming in from this lateral entry of lawyers. So there could be a situation where there is a lawyer who has about 10, that the law requires them to have 10 years experience. So there could be a situation that there is a lawyer who's entering the system as an additional sessions judge at, with an experience of 10 years, is trumping the possibility of promotion of a person who probably has more judicial service, and that's a problem. So that's not very fair as I see it, because you might have a civil judge who has 15 years of experience, earlier judicial experience, and he put it together as 15 years or 20 years, and here you have a person who's 10 years and comes and becomes senior, blocks this path also. So that needs to be reconsideration. I don't know if we can do it because the bar is now deeply invested in it, and it becomes a political issue, but we can consider it, whether or not we can stop it for a while and give preference to our judges, or maybe we can come up with a policy that judges who have more judicial experience need to be preferred first, and when we come to those judges who have less than 10 years judicial experience, we open the gate for lateral entry. Maybe these are some of the thoughts. And also when we talk about lateral entry, we could also then talk about giving preference to women here also. With the subject of the formula that I talked about, we can talk about women coming into lateral entry as a preference, because that preference system needs to be built in on the basis of Article 25. Just a thought, I don't know, one needs to think deeply about these issues later also. Then I think the Act would also talk about, we need to open this track going up to sessions judge, and that is creating a lot of frustration. And that could also be that we could have district judge looking at criminal division, we could have a district judge looking at civil division, we could have a district judge perhaps looking at family division, and you have three session judges in a district that opens up the room for people going up. Having said that, I mean, we could have a similar model of a chief district judge in a district, and he would be the senior most judge looking at the administration part. But I see no reason why we can't have more than 3 or 4 district judges in a district. So that would also open up that. And when you open up this, then a number of things happen. And as I said earlier, I qualify. When you open up this track, we are opening up, along with this track, preference card also, women going up also. So women are actually going a bit faster than men if we put the policy in place. Once you open the track, the women are the most advantageous of this new open track. So that would make a difference. We're just finding ways on how to get women into the system, which is also helping men also clear the system a little. So then the next thought that sort of crosses my mind, I was in New York and I was attending and some of my colleagues were there in New York with me. We were attending the World Jurist Association function. And the president of the World Jurist Association asked me, do you judges have associations? And I said, I haven't heard of that. And he said, why not? I mean, we have about, I don't know, number of countries here who are being represented. They all have associations. Why don't you have associations? And I said, well, I don't know, something that I need to think about. So I was just thinking, why doesn't district judiciary have an association? Why can't judges of the district judiciary have association? I think it's a very democratic principle, is it not? It's very democratic to have your voice heard through an association. And then within the district judiciary, you could have a women judges association, which would then talk about these issues that we're trying to talk about and fight for. Then they will fight for it themselves. So I think empowering women would not be just, you know, give them a toilet here, which is certainly we will, but the issue is to give them, you know, a sustainable system where they could then take care of matters themselves. For example, if we were to have this association of women within the association of judges, I think there'll be a very strong voice. They'll fight for it. I think harassment issues or transfer issues, a number of other issues could be talked about. As a Chief Justice, I felt that I wanted to talk to the district judiciary, and I didn't know how to talk to the district judiciary. Who do I talk to? The registrar? Okay. Or the MIT, who's always against the district judiciary somehow. So who do I talk to? And I tell you, this is a very odd thing that I've realized. MIT is out of you guys, and when a minute he becomes MIT, he says all these guys are bad. And I don't know why this happens. This is very odd, but anyway, we changed the term MIT also, which is also borrowed from the civil service. We turned it into a Directorate of District Judiciary in Punjab. I don't know what's the position in other districts, so other provinces. So association is another thought that we can think about, and that association, to my mind, takes up on its own momentum, would solve a lot of problems that we have and we're facing right now. So why can't we have this association? And tomorrow, Chief Justice of our province wants the issues that the association goes to the Chief Justice, says, these are the problems, sir. We're facing these problems. Nobody can communicate with the Chief Justice right now what the issues are. The Chief Justice will talk to some of the session judges, perhaps, and you know, who are close to him, or who he feels are credible names. But is that the way it should be done? So we, the High Court, created not an association, but a committee of various judges from various tiers, and we thought that was a corpus, that was a sample of representing the district judiciary. So I could hear what a civil judge has to say, what a judicial session judge has to say, what a female civil judge has to say. How do these voices get to the policy makers? I don't understand. I seriously don't understand that. How do your voices get there? By training, you're very quiet and decent, and you don't really say anything, because that's how the training is. And so I think association could give you that voice, and I think that needs to be considered. Whether at all, how do we do that? That's another issue. So as I said, there could be an association, but short of an association, there has to be some sort of a board or some sort of a body of the district judiciary. Suppose if you don't go the association route, there has to be some board of the district judiciary that I or anybody wants to talk to. Suppose I want to talk to the district judiciary in Balochistan. Who do I call? Is there a number? Who do I call? And is there a board and board of directors or board of whatever, members and something like this, who would tell me what are the issues of district judiciary in Balochistan or other provinces? So that model needs to be considered. Why am I saying this is just to empowering all the judges, but in particular, women gets empowered through a systemic change rather than just, you know, one-off interventions here and there. So I think it's a more sustainable kind of system. That's one. So we need to come up with a Judicial Service Act that may talk about all these various factors, give you a robust terms and conditions, and give you a system where there could be more voice that comes out, and they can sort of attend to their issues. The second issue was the judicial policies. Now, I think largely district judiciary is run through these notifications and policies right now, because there is no act for that matter. So the Chief Justice were to decide that finish 100 cases, please work hard, do these things, that kind of policies keep coming. They say, please decide all these cases and all that. But we have to see first and foremost whether all these policies are made, where are they made? Now these policies are made, as I see it, by the Chief Justice alone at the High Court level. So the first structural change I would suggest would be that the policies ought to be made where women are sitting with the policy makers. So this body which is making this policy must have some women. I mean, how would the Chief Justice know what policy to make alone if he's not a woman? So to start with, if you're making a policy at the Supreme Court, at the High Court, at the District Court, the policy body that's making the policy must have women. That's one very important factor. I'm sorry, I'm told there is a time limitation, but I need to say a few things. Don't mind, my just exceeding a little time. Can I speak a little more? So now, will of the people have spoken. Okay. So having said that, because that's very important, that the locale where the policy is being made, you need to have a woman sitting there. And it would be very unjust and very unfair that a man were to make a policy for large number of women in the system. That's slightly counterintuitive. Then we move on, that the policies should largely be to support work-life balance, flexible working hours, parental leave or leave issues, child care facilities, or so crucial for supporting women judges and staff. I haven't yet seen many such policies. I think the leave rules are the leave rules of the government. There is no proactive policy that goes ahead and provides a work-life or recreational facilities or working hours, or as if we've sat and thought about our judges and we say, okay, let's see how should they be working actually. I don't think that's happening. And we think, and I think we should do that, and we need to deliberate more on how to come up with these policies. We need to come up with a policy regarding anti-harassment. But let me also talk about this harassment issue. Current system, nobody's going to really, to my mind, talk about harassment, because that's just getting you nowhere. A woman, suppose, God forbid, she's being harassed. If she raises that question, she becomes visible. She doesn't know where to take this matter. Maybe nothing happens, and she just, takes an issue and can't really take it to a closure. So once we have more women coming into the system, once we have that association going, or once we have a body, I'm quite sure that these issues will be handled very well, because that voice will be stronger than the voice of this individual woman who's trying to raise this question about harassment. So once again, that side note that I put on the table, that we must try to get them in irrespective, and then talk about a number of other niceties that we're talking about. Policies that ensure women taking on a leadership position. We need to have policy which by design provides that women end up taking leadership positions. We don't have such a policy where we make sure that they become session judges, they take up positions at the Federal Judicial Academy or at the District Directorate of District Judiciary or others. And also, which is not the subject today, is the training part, which must provide. There are leadership training programs at the Federal Judicial Academy. Are we really also, and I think they are doing something on this, where we're preparing female judges for leadership positions, a dedicated course where we can, so that we tell them that, yes, you could be leading the district, you could be heading the academy, you could be doing a number of things. So that kind of a thing needs to be done. We need to also consider whether at all there could be a more gender-sensitive transfer policy. Now that carries a lot in it, and we talked about it when we were at the High Court, that children are studying, there could be a maternity issue, there could be a number of things, and off you go due to political reasons. The Chief Justice decided to transfer you. That should not happen. The transfer has to be purely through a rule-based system. It cannot be on the will, just because we just shift somebody. Number of cases this has happened, that you shift a person, the kids are being schooled somewhere, they can't be moved, the woman moves on one side, the husband is on the other side, and it totally disrupts the system. And I would imagine if I'm transferred in that fashion, I tell you, I can't do any judicial work properly. But anyway, everybody goes ahead and does it, they can't raise their voice, but I think that's very disturbing. And also, on the policy issue, lastly, this has to be an organic document, has to keep growing, has to be developing as we go on. We keep on making adjustments. It can't be made a policy and then we sleep over it. No, there has to be, and I propose, and I think this is an idea that I picked up from LUMS, when I think we need to have a diversity and inclusion department within the judiciary. And I think that's very important. And this diversity inclusion department will constantly be looking at our policies, constantly advising us what's going on, and that organic policy system making keeps on changing, addressing the current issues as they arise. So I think this diversity inclusion department should, as a policy, be made in all sorts of courts. Then coming to the other fundamental issue, and I'm exceeding time, and I think the organizers are getting upset, but I think I can get away with it. So the third thing is the infrastructural issue, the actual brick and mortar problem, and this has to be more conducive to women. I have seen that in Punjab, and I referred to it yesterday. The courtrooms, to start with, are pathetic. I mean, I have seen courtrooms which is as small as a toilet, where a judge is sitting, and the only wall between her and her reader or the almad is the shelf itself, the almari, which is the wall. And that is where she is, and she's practically sitting on the road, and people outside standing on the road can see her dispense justice. And that's not right. That's just not right. I, as a judge, could not possibly operate there, and I don't know how women and young women sitting in far-flung districts in such an environment are operating and dispensing justice. My salute to you for that. My salute to you. So this design, and then we can go on endlessly on the design issue. We can talk about toilets, we can talk about prayer rooms, we can talk about common rooms, number of things. I mean, attached toilets, all sorts of facilities. And that's important, and that's something we can't just lightly take, because the needs are different for women, and the needs of men are different. And we need to understand that. I mean, there are issues which women need to address, and that we need to provide that privacy and space for women in the system. That applies to Supreme Court, that applies to High Court too. But we must signal a commitment to gender equality and inclusivity in that sense, and we're not doing that. So proper courtrooms, as I said, and I'll just rush through this, I think we haven't yet come up with any recreational facility for judges. All we hear is, please finish 100 cases. That's all I hear. And I haven't heard, okay, what do you do in your free time? Where do you go? How do you chill? How do you relax? What do you do? But how do you unwind? Nobody is interested. Just finish those cases, please. And those cases will never finish, and I tell you that. They'll never finish. We will finish, the cases will never finish. This is a myth to say that the pendency is going to finish. It cannot. And we must come to terms with that. So what about a gym? What about a child play area? What about a prayer room? Is there a policy? Any high court has a policy which says, women, this is your prayer room during the day. Where is it? So they'll have to go find a place somewhere themselves. I mean, what kind of a policy is that be? So are we holistically looking at our district judiciary? Are we really understanding their needs? I'm talking about the policy makers, that's us. And are we sitting sometimes and talking about it? I don't know. I mean, I haven't spent any time where my judges and I sat down and we said, okay, what policy should we make for our district judiciary which would make them very comfortable? I don't remember a day when we had a meeting to this effect. And I'm talking about my tenure as a Chief Justice of Punjab, never. So then I would assume that maybe no other high courts haven't done either, but if some have done, credits to them. The other idea could be on the infrastructural idea would be that if we go around and have one judicial complex in every district. We have a judicial complex, but you have ex-cadre courts scattered all over in various plazas and all that. One big judicial complex with housing, with courts. And that is it. Instead of having all these, plazas and courtrooms, it is not difficult. This is not difficult. It caters to security, it caters to your housing, you can have your own playgrounds inside, that's your little estate. You go, you work in the morning, you have your housing there, you have your families there, you stay together, you work together, you bond together. I think that's one idea that one could float, that one single judicial complex per district. So that sort of security. The other issue, which is slightly more complicated, is the security issue. So if I were a woman and I've just graduated from a law school and I'm working at a law firm, and I say, well, if I become a civil judge in Punjab and I'm thrown at some of the districts, the lawyers insult me. They are very rude to me. And I don't know if I can handle those. And that will be my question to myself and to my family, that they insult you, I mean, they swear at you. Have you seen the things in Punjab, how the bar attends to a woman? That is not on. So that has to be done, and I don't know where bar members are. We need to talk about these things openly. We need to sit down and have a heart-to-heart on this. How will this work? How can you go ahead and insult judges? I mean, we need to really sit down and talk about it. In Lahore, in Punjab, we shut down districts where they insulted a woman, and then it remained shut for a while, and we opened it later on. So that's not on. Then also the behavior of their peers. I mean, this is also a problem, that a woman who's working, she's getting all this flack from the lawyers. All right. Then she's also getting a lot of flack because the peers are not getting her. They're not understanding her. And I blame them for that. They're not sensitized enough to deal with this issue, and that sort of takes us to training and all the other issues. But this is also an issue that I would think, if I am a woman and I have just graduated and I want to apply for a civil service job, I say, well, the judges don't understand. What if I'm in a far-flung district? My peers will have no understanding. What do? I'd rather not do law. Let me go join some other department. Because today, and yesterday and today, we're thinking about how to woo women into judiciary. So we need to provide a conducive environment for that purpose. So we need to think of all those things that worry us, you disturb us. We need to take those disturbances out, clear the air, so that we can get women into our system. And as I said yesterday, there has been a huge decline of lawyers, female lawyers applying for the post of civil judges. And that's very depressing, by the way. And then, of course, infrastructurally, should a judge, a female judge, have a female staff? Or do you want a man coming into her office all the time, even to attend to some of her very personal things? Should we not have a female staff? And yesterday I told you there are about 2% or 4% female staff out of 48,000 staff that we have in the country. So that needs to be considered. And then, of course, we need to also empower them. We try to do that in Punjab, but I'm sure the other provinces have done that also. Give them cars. Women must have cars. They must have, feel empowered to come to work, and a number of other things, and that list goes on. Then moving on to two other things, and I'll be gone soon. Ye chote si do baatein aur thi. Legal education and legal profession. We need to, and I don't have a study on it, and I think I would request somebody to do a study on it to understand, is the legal education tuned towards preparing young lawyers and giving them a vision that you could go join the judiciary also. I don't know if that conversation takes place at the law schools. Should we be reaching out to the law schools and telling them that here we are, we've come out to roadshow and tell you that, listen, we have a thing called judiciary, and why don't you sort of join this, and why can't we talk about to your students about it? So something like that, I don't know, but that has to be done. I don't know law schools really talk about that. I also feel that the legal profession, the law firms are not really geared towards that either. And I don't know how comfortable it is for women to work in law firms. I've been hearing things since yesterday that all sorts of things, the things are not very comfortable at law firms, and things are not too comfortable, around and going out to court. There is hardly any trust or confidence. They don't repose trust that you go ahead and go litigate this matter. So that's something beyond my domain and jurisdiction, but a study should look into that. What's happening? Why I don't see women in the court? Why don't I see them in the Supreme Court? I see very few of them. Where are they? Where are the women was the question yesterday. So that's the law schools part. And lastly, once again, which if I'm not an expert, is the cultural and the social barriers, which is the mindset of the society. Now that I can't, of course, as a judge and as a part of the judiciary change. We can change that through our jurisprudence, of course, but not otherwise. And that's another issue that we need to all think about. Do we send our daughters out to study law? Do we have a problem in our daughter becoming a judge, a civil judge for that matter, or applying for that? And if there are problems, that's a barrier for her. And that is something that, a societal issue, but it is certainly an impediment that I wanted to put on the table. And these things will have to go, will take time, but will go. But awareness, programs like this would be something that would help in that direction. So these are some of my thoughts on how structural interventions could take place It's a big basket, a number of things, but I think if we start working on it, start thinking about it, and I urge the panelists that are coming up to please think about this more deeply and see if we can find solutions. But the ultimate aim is how to bring more women into the system, and that is the judiciary. And these were some of my ideas, but looking forward to your ideas also. Thank you so much.